How to get a high grade in Tort Law. This is what you need to do. 4 simple steps. First, you need to analyze your exam requirements. So this means that if you have a coursework, then you have to go through the legal research and legal writing straight away. You don't need to revise everything that was covered on the course. But if you have an exam, and let's say you have to answer 4 questions out of 8, you can revise 4 or 5 topics just to have one as a backup. And once you revise those topics, make sure that you practice answering problem and essay questions on those topics. The thing is, most of the students most of the times forget practicing parts, and they just try to learn everything by heart about the selected topics, but this is a mistake that can result in a very bad grade. Only 50% of the job is done when you revise the topics that was covered on the course and you're going to answer on the exam. The rest of the work is to practice answering problem and essay questions. Answering problem and essay questions is not something you learn overnight. This is a continuous progress that requires enormous work. So even if you understand that you should do the ARC structure and you have a basic theoretical understanding of how to do the ARC structure, I strongly recommend that you practice as much as you can answering problem and essay questions on the selected topics. Do selective studying. So you don't need to study every single topic that was covered on the course, but select the ones that you understand the most. Practice answering problem and essay questions. As I said, it's very important for you to know how to answer problem and essay questions, how to apply your legal knowledge and legal writing skills correctly to common exam questions. And finally, make sure you follow professor's guidelines. Let me explain what this means. So in your lectures, you will be given essential reading list. And in this essential reading list, you will have a list of cases. And you should make sure that you use those cases because those are essential. That's why it's called essential reading. And a legal principle in your essay can be backed up by multiple cases, but you should always cite the ones that was highlighted in your lecture. The essential reading list should be in your essay, basically. Even if you find another case in your further research that can be cited because it has a similar principle, similar facts, always prefer to cite the cases that was in the essential reading list of your lecture. If you cite additional cases than those that was in the essential reading list, that's okay, but you cannot omit the cases that are in the essential reading list. Please remember that. Follow the right structure. So there are different structures that you need to follow for problem questions and essay questions. You probably have heard about the IRAC structure, but it is very important that for every single legal issue that arises in the problem question, you do IRAC and separate it in different paragraphs. So for example, if you have one legal issue, you deal with that legal issue with the IRAC structure, and then start a new paragraph and talk about the next legal issue. Do not mix 2 legal issues in the same paragraph because that can obscure the structure. The structure has to be very clear. Every single legal issue has to be dealt with absolute certainty, very clearly for you to get a first class. For the essay question, you have to discuss the relevant law, then make an argument. Law argument, this is the structure that you have to remember. When you are making the argument, it has to be based on the primary law and always referring back to the question. many times students make this mistake that they are very explanatory. So when they see, let's say in tort law, if you have an essay question about duty of care, what students do is they just write everything they know about duty of care, which is the most common and the biggest mistake you can ever make, can result in a fail. Because when an essay question is asking you about duty of care, it is not going to ask you to write everything you know about duty of care. You have to answer the question asked and make sure that you read the question carefully and understand what it is asking you. It's always about arguments. The quality of your arguments is the most important. It's not about how many cases you put in there. You probably think that you could impress the professor if you put too many cases in there, common mistakes for new law students, but you should not do that. It's not about putting as many cases as possible. It's about quality of your arguments. Your arguments must be very clear, and that's how you get a first class. Also, you should show good research. As I said before, everything that was mentioned in the lecture, the relevant parts obviously, should be in your essays, in your answers to problem questions and essay questions. However, first class students also do additional research more than what was on the lecture. And if you show good research, if you have read peer-reviewed journal articles and correctly integrated it in your essay, most likely you should get a first class. Today's topic is occupiers' liability. I would like to do a practice question about occupiers' liability. We can read this question and do the IRAC structure later for answering this question. Theme Park Ltd owns an amusement park that Jack and Natalie Smith visited. They went to the park with their 5-year-old son, James. On one of the rides, despite the staff members' warnings, James put his finger between the carriages and sustained cuts. The family wanted to find a nice place to relax and have a picnic. They climbed over the amusement park's fence, ignoring the warning not to pass it. Due to the erosion on the edges of the park, the bank collapsed and they all sustained serious injuries. Advise the parties as to what rights and remedies they can have in tort law. The first legal issue on the facts of the case is whether or not James has a case in tort law against the park. You have to first discuss if James is a lawful visitor, because that is very important. If he's a lawful visitor, then it should be Occupiers Liability Act 1957 that applies, and the scope of the duty is different too. If he's a trespasser, in that case, there is a different Occupiers Liability Act that should be applied. In this case, because he's visiting the park and most likely he has a ticket, so he's a lawful visitor, he's not a trespasser, and Occupiers Liability Act 1957 should be applied. One more very important thing for you to remember is that you should always cite in your footnotes relevant sections from the statute, or if it's a case law, then cite the relevant case. For tort law, it's mainly common law based, so you will most likely have to cite cases most of the times, but for occupiers liability, it's a statute, it's Occupiers Liability Act. So make sure that you cite the relevant provisions from the statute for every single legal issue. For analyzing whether or not James is a lawful visitor, it's Section 2 of the Occupiers Liability Act 1957. According to the IRAC structure, you would first put that the legal issue in this case is to analyze if James is a lawful visitor. That's a legal issue. The rule would be to explain what Section 2 says of the Occupiers Liability Act 1957. The application would be to apply Section 2 to the facts of the case and conclude that most likely James is a lawful visitor because he should have a ticket. He bought a ticket to enter the park, and that grants him a license to be lawfully in the premises of the park. Occupier's liability for child visitors is set out in section 2(3)(a). Therefore, the next legal issue is to analyze the scope of the duty. When someone goes to an amusement park, the company that operates the amusement park has a duty of care towards all the visitors, all the lawful visitors, and there is a certain requirements, certain requirements for this duty to be discharged, and the details of that is set out in section 2(3)(a) of the Occupiers Liability Act. Occupiers liability for child visitors is that they should take into account children are less careful. So there should be some additional warnings, additional precautions for children, especially in amusement park, because amusement park is often visited by underage children. What we have to discuss is if the premises are dangerous as a result of a reasonable use. And you should cite the case of Wheat versus Laken. In this case, James put a finger between the carriages. Is that an unreasonable use? Most likely, yes, because you're not supposed to put a finger between the carriages. You can cite the case of Wheat versus Laken. Possibly, it can be argued that since James is a child, staff member of the park should have taken further actions, further precautions to make sure that he does not get hurt. However, you should have a look at the case of Phipps versus Rochester Corporation, where it was established that the parents have an obligation to take care of their children. So when they are in the amusement park, they should have a look if their children are engaging in any dangerous activities. Liability for injuries sustained when they climb over the fence. Once you complete your discussion about James, then you should discuss what are the potential liabilities that arises for injuries that they sustained when they climbed over the fence. Can they sue the amusement park for leaving the edges of the park in this dangerous state that is resulted in their injuries, or because they were trespassers, they may not have a claim? That's what you need to discuss. The fence was located at the edges of the park with a warning prohibiting anyone to climb over it. Since they climbed over the fence, ignoring the warning, they can be a trespasser. Duty of care owed to non-visitors, trespassers, is not governed by the 1957 Act that we discussed before. It is governed by the Occupiers Liability Act 1984. And you should cite the relevant statute when you answer a question like this. Section 1(3) states from the 1984 Act that there is a duty of care if the occupier knew about the danger or had reasonable grounds to believe it existed. So the fact that they were trespassers, it does not mean that they are not owed a duty of care, but the scope of the duty of care is different, and you have to discuss that in detail. Occupiers are reasonably expected to provide some protection against the dangers of their property, even for trespassers, according to the 1984 Act. Further warning about the fact that the bank could have collapsed due to the erosion may have prevented them to go there. So the argument here is that, yes, there was a warning, but maybe the warning was not explicit enough for them to understand the danger. So it can be argued that they they could have made the warning more explicit to explain better where could have been the consequences of climbing over the fence, and that could have prevented the accident. If the court accepts that argument, in that case, then yeah, they could get a compensation. But if the court takes the view that the warning that was placed there was enough and was explicit enough, and they should not have climbed over the fence, then they may not be able to get compensation. They may not be able to get compensation for their injuries because they were trespassers and they ignored the warning sign. However, if the court believes that the warning was not clear and they should have specifically warned about the erosion, they may be able to get some compensation, as I explained before. And the authority for this that you should cite is the case of Tomlinson versus Congleton. If your lecturer is citing another case, then use the case that your lecturer is citing. Therefore, to sum up, the recommended structure for answering a problem question on occupier's liability is the following. First, establish the parties in dispute. Who is the claimant? Who is the defendant? Use subheadings to advise each party separately. Most of the times, when I see problem questions on occupier's liability, there are different incidents and different parties involved. You have to divide your answer in separate subheadings and advise each party about each incident separately to make your structure very clear. Establish if the visitor was visiting lawfully or unlawfully. Very important, because whether or not the visitor was lawful or unlawful, according to that, you have to apply the relevant statute. But if it's a 1957 Act, that's for lawful visitors. If it's 1984 Act is for unlawful visitors, trespassers. And discuss who is the occupier. It's section 1(2) of the OLA 1957. You have to, most of the times it will be clear who is the occupier. In this case, it was the company that operated the amusement park, but sometimes it's not very clear. So make sure that you discuss, even if it's clear, you still have to define what is an occupier and apply to the facts of the case and say who is the occupier. Discuss the scope of the duty of care and apply it to the facts of the case. Apply the relevant statute, like it's 1957 Act or 1984 Act, and explain in detail what are the requirements in the duty of care and if those requirements were met. So according to that, the next legal issue would be to discuss if there is a breach of duty of care. Applying case law. For breach, it's usually the authorities should be the case law and make sure that you apply the case law that was cited by your professor on your occupier's liability lecture. And in addition to that, you can have a look at our notes and do further research to see if there is any other case that you could be citing that could improve your analysis. Finally, you should discuss if there are any defenses that applies in the facts of the case. Defenses, contributory negligence, voluntary non-fit injuria. This is the one when consent to the risk, there is a consent to the risk of injury. If there is exclusion clause, that can be a defense. You should remember that Consumer Rights Act 2015 and Unfair Contract Terms Act 1977 can prevent occupiers from excluding their liability for injuries caused from the breach of duty imposed by the Occupiers Liability Acts. And finally, don't forget to mention the remedies as well. Remedies is usually straightforward. You should mention that the remedies would be monetary compensation. Tort law. We have study materials for tort law on simple studying, and you should have a look at it for further information. We have model essays as well that you can have a look to see in complete version of an answer to a problem question or an essay question. We have tutorial videos as well, where we explain how to answer problem and essay questions. Flashcards, quizzes, revision notes, that covers everything that you need to know for tort law, without reading thousands of pages of complicated law textbooks. You can also book a tutoring session for personalized support. And now I'd like to tell you a little bit about our services and us, our team at Simple Studying. Our content creators and tutors are successful law graduates who got very high grades in their degrees. We are from different English universities such as LSE, City University. We're not associated with these universities. We hire their best graduates. In addition to the ready-to-go first-class study materials that we have on our platform, and you can get them, we have tutoring for personalized support. Tutoring is very important. Most of the time, students need our materials plus tutoring to maximize their chances of getting a first-class law degree. During tutoring, you will be able to meet with the tutor on Zoom one-to-one and discuss whatever you may need help with. Most of the time, students give us their coursework, assignments, or we help them with answering practice questions because they have an exam coming up and they need practice and they don't understand how to answer problem and essay questions correctly. So we help them with guidance and guidelines and preparation for exam and courseworks. We have already helped thousands of law students get very high grades. As you can see on our reviews, we have almost 25,000 registered customers on our platform, and 90% of our regular users get a first class. If you'd like to get a first class, I suggest that you join Simple Studying now and get a premium subscription as well as tutoring session to maximize your chances of getting a first class.